on inventive step in manual of patent practice and procedure of Indian Patent Office. Such devices which don't have any non-obvious working interrelationship don't deserve patent at all. At best as they are contending they have some efficiency, at best it can be regarded as a workshop improvement, but that too is not patentable as per the decision in Polar Industries and versus J Engineering Manufacturers. In addition, my opponent counsel has heavily relied upon commercial success of their patented product. But if I may draw your attention to cases like Gandhidham Appliances Limited versus LG Vardharaju and the seminal case in House of Lords, that is Iverman versus Jackal International, it has been very categorically stated that commercial success never means there is some kind of non-obviousness. Therefore, my lordships, their product doesn't deserve a patent at all. And nextly, if it pleases my lordship, the council would like to
see. I mean, the issue before the High Court is not whether to declare their patent valid or invalid as of now. The issue is the infringement of the patent by your client.
My lordship.
How do you maintain that?
My lordship.
The argument is not, to declare their patent as invalid as of now. The patent is given in 2007 and you have been infringing is their allegation. How do you answer that?
Indeed, my lordships. My lordships, in this counterclaim, we are alleging that their patent is invalid, and nextly we will also show in my next contention.
In that context itself, their argument is that if there are multiplicity of proceedings, because on one ground you say that it is invalid and you maintain your counterclaim. On the similar ground, you go before the tribunal and say, look, this is wrong, so invalidate that. So how do you maintain two proceedings at two different forums?
My lordships, in that regard, I would say that the statute is clearly provided us an avenue to file a counterclaim. We are not, and as I already argued, the doctrine of election doesn't apply here because both the remedies.
It's not doctrine of election. It is multiplicity of proceedings.
My lordships, the statute is humbly submitted to.
See, on one hand, you are before the tribunal, asking the tribunal to invalidate their patent. On the same ground, you are before the High Court again, saying that their product is invalid. I mean, their patent is invalid, so therefore give us the claims. How does the High Court deal with a similar issue again?
My lordships, Section 107 gives us a right to file a counterclaim before this honorable court. So nextly, this is a statutory right, and the Alloys-Owen case, my lordship, the Alloys-Owen case, the Delhi High Court said that it can be filed before the High Court. The Supreme Court decision in this regard, it will be our humble submission, may be declared per incurium by this honorable High Court, and in the case of my lordships, Sandeep